Welcome to a lecture on utilitarianism. I always like to start with the authors of this moral philosophy, and the dates are important as well. You can see that Jeremy Bentham wrote the first treatise on utilitarianism in 1789. Obviously an important date constitutionally if you think about the Declaration of Independence in 1776 and the 15-year period before the Constitution with the Bill of Rights was ratified in 1791. Certainly utilitarianism was a philosophy that the Founding Fathers understood and debated and may have pushed them toward protecting certain individual rights in the Bill of Rights, more so than without this utilitarian philosophy. As with all great ideas and movements, right, there was a reaction against utilitarianism, which was, really Immanuel Kant's Metaphysics of Morals, 1785, and many other essays after that, establishing his philosophy of natural law and moral principles. And the other important document, obviously, is 1690, John Locke's Second Treatise of Government. All of these are working together in this burgeoning, sort of boiling pot of moral philosophy that informs our understanding of the Constitution. But it's John Stuart Mill who revived utilitarianism from Bentham's essay and really has become the sort of modern authority on this way of thinking about the Constitution. I want to separate two things before I move on to the next side, and that is that utilitarianism is going to be the legal version of reader response. Okay, and we're gonna call it. Sometimes I'll call it utilitarian consequentialism. Sometimes I'll just call it consequentialism. But it's looking to the results of an action, the results of a law, and looking to yield the greatest good for the greatest number, the famous phrase from Mill's essay on utilitarianism, as a way of interpreting the Constitution. Okay? So we have, author, historical context up here. We have the text in here. We have the moral philosophy of Kant in particular, and of Locke, natural law, and we have doctrine over here, right? The precedent, all the concepts established in precedent, and what I'm going to argue down here is consequentialism, utilitarianism, okay, as a reader response way of interpreting the Constitution, okay, as a looking to the interpretation that yields the greatest consequences on oneself is reader response, right? Remember, you list you look at the pre-reading expectations, you look at the reading process, and you look at the possible available interpretations to you based on your life experience, and then you choose the one that has the greatest impact upon you. Well, the justices do the same thing. They look at the possible interpretations of equal protection of the laws, and they say, okay, all right, well, which one will yield the greatest act of liberty, is the phrase that Breyer uses, for the greatest number of Americans, and they choose that one, and they are very open about being results-oriented, looking at the interest-balancing approach, or looking at trying to yield the greatest liberty for the greatest number of Americans. All right, well, let's get into it. Okay, so utilitarianism, Bentham wrote as a way of determining the moral worth of an action, whether or not something is just. And he wrote, justice is determined by the principle of utility. That's a phrase we're going to use. That will produce the greatest happiness for the greatest number. For Bentham, this principle of utility is grounded in whatever promotes the most pleasure and decreases the most pain. That's very controversial, right? But collective happiness may come at the expense of violating individual fundamental liberties. Can the principle of utility, is the question, command while respecting individual rights? Now this is the central controversy that I want to get to in a second. But the principle of utility is the idea that the justness of an action, the moral worth of an action, is determined by its utility, its ability for Bentham to increase pleasure and decrease pain, increase happiness, decrease unhappiness, increase good and decrease evil, or displeasure. And so that's the principle of utility. Now, the central question for the Kantians, right, the natural law moral philosophers, right, versus the utilitarian thinkers, we're going to call them consequentialists on the court, right? Natural law moralists. Is, can these principles, like all individuals need to be treated equally before the law, that sort of natural law principle, we all have reciprocal, equal access to life, liberty, and property, can those principles be upheld while yielding the greatest happiness for the greatest number, the greatest pleasure, and decreasing the most pain? Okay? That is the controversy. Okay. So Bentham wrote, an action is conformable to the principle of utility when it augments the happiness of the community more than diminishes the happiness of the community. It seems like an easy concept, and it's something we're going to see in Breyer's philosophy in his book called Active Liberty, about how to promote the most active liberty for the most citizens in the United States. So how do we determine whether an act follows the principle of utility? And this is the interest balancing approach. He says, Bentham writes, you sum up the numbers expressive of the degree of good tendency while the act has with respect to the individual and for the whole, and take the balance which is on the side of pleasure, and Mill comes around and places that with good, and he qualifies good, not just pleasure, with respect to the total number of community of individuals concerned. Let me pause on this again. Let me review the language. Sum up the numbers of expressive of the degree of good tendency which the act has with respect to the individual. Okay, individual, right? And for the whole. Okay, so the amount of good, pleasure, happiness yielded for the individual and the community, and then take the balance on their side, respect the total number of community of individuals concerned. So, interest balancing approach is trying to yield the greatest collective happiness versus the greatest corrective unhappiness. And obviously you choose the action, you choose the law, you find the law more just, that brings more happiness, more liberty, in Breyer's phrase, to the community. But let's look at an example. Let's go to the next slide. Do an example. Let's talk about affirmative action. Okay, in affirmative action, we have a policy in state institutions, at least in the University of Michigan undergraduate policy, that rewarded 20 points for race alone, without looking at whether or not that individual would contribute to the robust exchange of ideas that stems from an educationally diverse classroom. Okay, just 20 points for being Native American, being Hispanic, or being African American. Okay, that's policy. Well, what principle does that, as we go back to our Kantian way of thinking, go back to our Lockean way of thinking, well, what principle is adversely affected by that policy, or at least implicated, I should say, in that policy? Well, we know from our 14th Amendment the equal protection of the laws, that all citizens are equal before the law and should be treated equally with respect to attributes they cannot change. Okay? You should not be treated differently before the law because of your height, because of your skin color, because of your eye color, because of your genetic makeup, something you had no power over. Okay, well, affirmative action, that policy in particular, adversely affects that. Well, the utilitarian comes around, the justices, the consequentialists will look at it and say, look, the benefit of the robust exchange of ideas, of an education diverse student body that prepares students for a diverse workforce, that gets Americans interacting with underrepresented minorities, and creates that expectation in the workplace, or at least a familiarity with that, and desire to have that interaction in the workplace, is a good thing for America. It's a good thing for the individual. It's a good thing for underrepresented minorities. They get a better education than they would without the affirmative action policy, and it's a good thing for the robust exchange of ideas in the classroom. So therefore, right, it promotes the greatest happiness, it has the greatest utility, it promotes the greatest good for the greatest number, including the individual, and that far outweighs the violation of the principle that individuals are not being treated equally before the law. Okay, that's the utilitarian argument, that's the consequential argument you're going to hear, or have heard, from justices. Well, Mill goes on to say, to qualify a little bit more, the utility or the greatest happiness principle, okay, principle of utility, or greatest happiness principle, holds that actions are right in proportion as they tend to promote happiness, wrong as they tend to produce the reverse. Pleasure and freedom from pain are the only things desirable as ends. Justice is the means to the promotion of pleasure and the prevention of pain. Okay, and you need to qualify what pleasure means. He says some kinds of pleasure are more desirable and more pleasurable than others. It's better to be a human being dissatisfied than a pig satisfied. Better to be Socrates, well-educated and cultured, dissatisfied than a fool satisfied. Okay? So he makes the argument that, all right, it's not just promotion of pleasure, it's not this hedonistic approach to life that, go ahead and sleep with whoever you want and do all the drugs you want, just as long as you please yourself. Promotion of the greatest pleasure is the goal. No, he's saying there's certain qualities to pleasure, to the good, that the individual must consider. Okay? And certainly when we look at the Supreme Court, Breyer is looking at active liberty, the most liberty for the individual, and he's not looking just to promote pleasure. So, Mill goes on to write, all honor to those who abnegate, deny for themselves the personal enjoyment of life, when by such renunciation they contribute worthily to increase the amount of happiness in the world. Remember, his measure is, go ahead, deny yourself certain pleasures as long as you're increasing the happiness in the world. Okay? But he who does it denies himself pleasure, denies himself happiness, denies himself a certain good, for any other purpose is no more deserving of admiration than the ascetic, right? The monk-like individual who denies himself pleasure mounted on his pillar. He may be inspiring proof of what man can do, but surely not an example of what man should do. And he goes on to say, a sacrifice which does not increase or tend to increase the means of happiness of others or mankind is wasted. Okay? Now, here's where Kant disagrees. Remember from our Kantian Metaphysics of Morals lecture, Kant said the highest moral worth of an action is an action that follows a principle. When following that principle, denies for oneself a desirable end. Okay? What does that mean? Well, let's say, for example, let's take abortion. Okay? Another issue that has, moral philosophy, natural law implications, and consequential utilitarian perspective. Let's concede for the sake of argument that the fetus is a life. Well, the Kantian, Lockean natural law moral philosophy would say you have to preserve that life, right? That life for Locke is sacred. For Kant, it is to be respected because it's a rational, independent, autonomous being that is worthy of our respect and is not to be disposed of. All right, well, so there's the principle. You can't deny it. You can't take away that life, right? That innocent life. And then there are the consequences, right? The consequences on the abortion issue, some among many, would be that to abort the fetus would prevent the fetus from having an unhappy life, raised in unstable conditions, protects the psychological health of the mother who is not prepared to raise the child. Say it's a 15-year-old girl in high school. Aborting the fetus will prevent the child from living in poverty if the mother is unable to provide financially for the child, and the father is unable to as well. And so there are many, it decreases the impact of unwanted babies upon the welfare system, the criminal justice system, and you could go on and on. The adoption agencies, you can go on and on. There are many great consequences. And so, look, utilitarian comes around and says, all right, what promotes the most active liberty? Well, we want to give women that choice. We want to give women that ability to make that choice up until viability, up until they're independent. And so all of those wonderful things that I just listed as great utilitarian consequences promote the greatest good for the greatest number, right? And that violation of that principle, right, of protecting life as sacred, life as worthy of our respect, not to be disposed of, as we get from our second treatise of government, we get from the metaphysics of morals, is not commanding when you see all those consequences. Okay? So a sacrifice, that woman carrying that baby to term, which does not increase or tend to increase the means of happiness of others, of mankind collectively, is wasted. Okay? So for those of you that are advocates for reproductive rights, utilitarian philosophy, Mill and Bentham become very important. Okay, the goal of utilitarian justice is for each individual to possess a direct impulse to promote the general good, that it may be in every individual one of the habitual motives of action. Okay? Good. Critics claim that utilitarianism renders men cold and unsympathizing, that it chills their moral feelings toward each other, right? And this is the great criticism that Mill anticipates from Kant, or he knows from Kant because he wrote in 1861 and Kant wrote his in 1785, that it makes them regard only the dry and hard consequences of action, not taking into account their moral estimate from which those actions estimate. So this is the issue that we were talking about, and with abortion, with affirmative action, right? Critics of utilitarianism say that they're so results oriented that they ignore the moral principles involved, right? But he argues men go out with their minds made up about right and wrong, right? It's in you, it's in your conscience. One must balance conflicting consideration. Rules cannot be framed so as to require no exceptions. Okay, this is very much the consequentialist view of justice on the court. One must accommodate the peculiarities of circumstances. There is no case of moral obligation in which some secondary principle is not involved. Okay, let's talk about that. All right, so what's the primary principle? The primary principle is the moral principle, right, that we talked about, right? So what Kant wants us to look at, right? When we're talking about affirmative action, it's the desire for all individuals to be treated equally before the law, to be treated equally with respect to attributes they're powerless to affect. The secondary principle, and this is important, for consequentialists, for utilitarians, is the utility principle, right? The principle of utility, of promoting the greatest good for the greatest number. Okay? You have to look at both of them, and you have to look at the peculiarities of circumstances. Okay? You cannot make hard and fast rules that that principle must be followed all the time, in all situations, in all cases, and cannot be violated. When certain circumstances, they would argue that the results-oriented approach yields far greater happiness, and should be followed even when a certain moral principle is adversely impacted. Really important. Okay. So, where does this leave us? Justice Breyer, in his book Active Liberty, as I mentioned, famously has said, law is tied to life, and justice should look to consequences, including contemporary conditions, when rendering an opinion, when determining an interpretation of a certain phrase of the Constitution. Okay? So, what I want you to do is I want you to press pause after I read these questions for you, and in your Google Doc journal, under Utilitarianism video, I want you to answer these two questions. How has Justice Breyer decided cases on affirmative action and post-viable abortions? Right? Cases that implicate the first moral principles of the obligation to preserve life and the obligation to treat all people equally with regard to attributes they cannot control. Okay? How has he favored the utilitarian consequentialist approach, results-oriented approach, the interest-balancing approach that favors the wonderful things that are yielded from affirmative action and from granting women reproductive rights, even post-viability, over violating the moral principles that are listed there. And how does this make him a utilitarian consequentialist? And for shortness of terms, we're just going to call him a consequentialist, right? Looking to the consequences as the determining factor for interpreting a phrase of the Constitution. So, just in summary, as you go forward and answer those questions, utilitarians, Bentham and Mill, and the justices on the court, currently Justice Breyer as spearheading the consequentialist movement on the court, want to promote the general good, right, overall. And they agree the primary principle is important, but they think the secondary principle of utility is also important and can outweigh and override following that first principle. Okay? Which one holds more sway often for consequentialists? Certainly the secondary principle of utility. And they would argue that it depends on the circumstances. I'll leave you with one more case, the Seattle case. Right here we have this, desire for schools in Seattle and in Lexington, Kentucky, to reflect the racial demographic of the city. And we have this, great white flight to the suburbs where we have these imbalance, we have these all-white schools, we have these all-black schools, and so they wanted to create that balance. We know this. And so what happened there is when oversubscribed schools, one of the issues, one of the ways to determine who gets to go where is the tiebreaker is solely based on race. Okay. Now, for Breyer, who wrote a 90-page dissent on this, he said, look, right, the reality of Brown versus Board of Education, 1954, that great decision, that 9-0 decision that said we were going to desegregate the schools, the reality on the ground, the peculiarities of the circumstances are that we have retreated back to Brown versus Board of Education days, back to the 1950s and 1940s. We have not de jure segregation by law. We have de facto segregation. We have segregation of blacks and whites and other underrepresented minorities by the fact of the situation, de facto, by the reality of the suburbs and the Great White Flight. Okay? And so what are the consequences? What's the first principle? I should say, right? The first principle is that you got to treat all people equally before the law. Race is an arbitrary attribute. You cannot make adverse or positive judgments based on race alone. Okay? Right? Equality is the first principle. Now, what's the principle of utility here? Well, he's saying, look, the robust exchange of ideas formed from a diverse student body, a diverse classroom, is a good that outweighs the violation of the principle that race should not be a deciding factor in school placement. Okay? So one of the great goods that come from using race as a deciding factor in this case is that you get educational diversity. You get individuals who are better prepared for an educationally diverse higher education, educationally diverse workforce, and you promote cross-racial understanding. Right? And that is what desegregation was all about. Okay? So he's very much a realist, right? Very much a pragmatist. Justice Breyer emerges as an individual who has carried on both Bentham and Mill's utilitarian view. So the question to you, and you answer in those two questions, right? How has he emerged as a utilitarian, a consequentialist, with abortion and affirmative action, is what do you think? Or does it depend on each case, right? Do we need to look at the consequences and look at the first principles of morality involved? Thanks for listening.